She insists she doesn't need a lawyer. She believes she can take on the court alone. But when Miss Pugh steps up to represent herself, reality hits hard. Inside this Texas courtroom, confidence meets the Constitution, and the judge is about to remind everyone what happens when you challenge the law without knowing it.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family, a living sovereign, one of the people.
Assistant Public Defender Don Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm.
The hearing begins with quiet formality. The judge announces that Mr. Jeff has been appointed to represent Miss Pugh. He's just received the case. No time to prepare. No time to breathe. The judge decides to reset the hearing to give him time. But even before the words finish, Miss Pugh's expression tells a story. She doesn't want a lawyer. She wants control.
That they had spoken almost every day, and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I looked at the video, and I also filed some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial schedule or anything else.
Mr. Martin, I've decided on all.
The judge glances toward the prosecution, confirming prior discussions. This isn't the first time Miss Pugh has raised this issue. The prosecutor nods slightly. They've been here before. The courtroom shifts in its seats. The pattern is familiar, and so is the frustration.
Motions that you brought before me, and the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
Really not prepared.
I think my words were very clear.
I understand what you're saying. You're saying because I didn't style it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
I mean, they're denied, but you didn't rule on it. How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to.
Miss Pugh interrupts the judge mid-sentence. The tone changes instantly. Miss Pugh, stop talking over me. But she keeps pushing. She insists on speaking for herself. The judge, calm but stern, finally offers her what she's asking for. If you want to represent yourself, we'll begin that process today. But there's a warning in her voice. It's highly inadvisable. The temperature in the room drops. Everyone senses it. This is
moved to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not. But I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to that. The third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence I was doing.
Martin.
The judge lays out the truth. Representing yourself means following every legal rule, evidence, objections, courtroom procedure. She explains how lawyers spend years mastering these skills. Miss Pugh listens, silent but unshaken. The judge continues, "You'll be at a disadvantage if you don't know the law." It rarely ends well. It's not scolding, it's a warning. But Miss Pugh seems ready to take that risk.
And you're going to need to speak up if you want to have a transcript of this, because it's not.
I'm speaking up.
Let's see, Heather. Okay. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
We're kind of a little closer now. How's that?
Is that any better?
How's that?
How's that?
That one clear.
Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true, because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Benton.
The judge begins the formal process required by law. She asks the standard questions. Have you studied the law? Have you represented yourself before? Do you understand the charges against you? Each answer is short, cold. No, then comes the key question, the one that decides everything. Do you understand the range of punishment if you're found guilty? Miss Pugh hesitates. The silence feels long. Finally, she whispers, "I don't understand." The room goes.
Case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit.
The judge explains patiently. She reads the charge, an offense from June 22nd, 2021. If convicted, the punishment could be between 2 and 10 years in prison. Miss Pugh stares forward, unmoved. The judge asks again if she understands. Miss Pugh repeats, "I don't understand." The judge stops. The law is clear. A defendant must comprehend the process to waive their right to counsel. And she doesn't.
Courthouse on Lafayette Boulevard. Right now I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle. They need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising their right to travel.
So, Your
I'm
Honor,
putting a
since
stop to it.
I'm sorry, Mr. Martin, since Mr. Martin has again, made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case. We will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this?
The judge tries again. She explains what a jury does, how guilt is decided, how sentencing works. Miss Pugh keeps nodding but then says softly, "No, I don't understand." It's the final confirmation. The judge exhales, her tone shifting from patient to decisive. "Miss Pugh, I'm not going to allow you to represent yourself because you don't understand the law and the process." A ruling.
I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
But how do you,
Um,
so you deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as indicated, as I indicated in my demand under the U.S. Constitution. Only the
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
The air feels heavy. Miss Pugh's chance to stand alone has vanished. The judge reaffirms that Mr. Jeff will remain as her attorney.